Hi, once again I'm Alexander Haberbush, and nothing in this video constitutes legal advice. This video is sort of a follow-up to my previous Ask an Attorney video on the Second Amendment, specifically on constitutional carry states. I realized there was one more thing that I probably should have mentioned in that video, and that is the Usv Miller decision. That's a 1939 decision made sort of during the height of the New Deal, in which the court reviewed a case in which a man had been charged with carrying a sawed-off shotgun, a shortened shotgun, in interstate commerce without paying the requisite federal tax that was levied against such weapons. And he had appealed, well, I guess not, sort of an interlocutory motion that was heard by the court, asserting his Second Amendment rights, saying that they could not restrict his ability to carry such a weapon in interstate commerce. Now, before we get to the merits of that opinion, when you hear the words interstate commerce, that should make you think of Congress's commerce power that's articulated in Article 1, Section 8 of the Constitution. As we know from previous content Lex Rex has put out, there's not a whole lot of powers that Congress has, only a few of them. One of those powers, though, probably the most extensive as it's been applied after the Constitution was written, is the commerce power. And what that says is that Congress has the authority to regulate commerce between the states. This has been interpreted very, very broadly by the courts, I think far more broadly than it was ever intended to apply. But typically, if Congress wants to regulate something, what they will do is they will regulate that thing in interstate commerce. So what they'd done in this case is they levied, I think it was a $200 tax on certain firearms when they were transported in interstate commerce, which is what Miller, the defendant in this case, had done. The lower court said that his Second Amendment rights had been infringed by enforcement of this law against him. And when the issue went to the Supreme Court reversed the opinion of the lower court, saying that his Second Amendment rights had not been infringed. What reason did they give for that? Well, this is the most often quoted part of the opinion, and essentially there's a variety of other things as well. And the facts of this case are really, really interesting. They're worth looking into. Some kind of crazy stuff happened with this, honestly. It had to do with all the government, federal crackdowns on mafia activity and whatnot. But essentially what the court ends up saying in relevant part, the part that's most commonly quoted, is that his Second Amendment rights had not been infringed because a shortened shotgun is not the sort of weapon that would ordinarily be used by a state militia or by a military. And this was used for years and years and years. This was sort of considered controlling law on Second Amendment issues. That is prior to the Heller decision, which is now considered controlling law. And many courts had interpreted this to mean that the Second Amendment only applied to state militias. But if you listen to what I just said a moment ago, the opinion didn't actually say that. It said nothing about who was protected by the Second Amendment. It just talked about what sort of weapons the Second Amendment applied to. And it said that because sawed-off shotguns weren't the sort of thing to be used by a state militia, it didn't apply there. Now, in 2008, when the Heller decision was made by Justice Scalia, there was a lot of really bad reporting. You still see some of this really bad reporting today, where people claimed that Heller had overturned the Miller standard. Overturn happens when one court case contradicts or reverses the ruling of an earlier opinion from the court. That didn't happen here. In fact, Scalia explicitly addresses the Miller opinion in the opinion that he wrote in the Heller case, and distinguishes it from the case that's before him, saying exactly what I just said to you. That didn't pertain to who was protected by the Second Amendment, just pertained to what sort of weapons fall under Second Amendment's jurisdiction. So no, the Miller decision was not overturned by Heller, although Heller did certainly clarify that ruling in Miller to show that no, Second Amendment does indeed apply to individuals. And Miller may still be good law. Court could still cite that if it wanted to say that a particular weapon is subject to congressional regulation. We're not quite sure how that would work out yet, since there's not a whole lot of jurisprudence on the Second Amendment, as I mentioned in the first part of this video. But I just wanted to address that. So that was considered controlling law for a long, long time, and that's sort of what it said. Again, nothing in this video constitutes legal advice, and I will see you all again on Friday.